Well, good morning, everyone. I am delighted to be here this morning with former Justice of the New Hampshire Supreme Court, John Broderick, who served on our court for 15 years, 6 of those as the Chief Justice of the New Hampshire Supreme Court, and with UNH Law professor Erin Corcoran, who, in addition to teaching law at UNH, as part of her classes also talks about the process for nominating justices to the Supreme Court. So we are here this morning to say it is time for the Senate to do its job, to hold hearings on Merrick Garland's nomination and to give him an up or down vote. The fact is, unfortunately, this is the first time in the history of the United States where we have seen a majority in the United States Senate refuse to consider a nominee for the United States Supreme Court. You know, the fact is the Constitution says the President shall nominate and the Senate shall advise and consent. Each of us, when we became United States Senators, took an oath that said we would uphold and protect the Constitution of the United States. We need to get on with it now to go ahead and move forward with Merrick Garland's nomination. You know, the idea that we should not do this in an election year is just something that's been made up for partisan reasons. The fact is, 14 times in the history of the United States, the Senate has acted in an election year on Supreme Court nominees, most recently in 1988 when Ronald Reagan sent over the nomination of Anthony Kennedy to a democratically controlled Senate. The Senate acted on that nomination in February of that election year and voted 97-0 to confirm Ronald Reagan's nominee, Anthony Kennedy. So this is, again, something that is a response to the most extreme voices that we're hearing in the country right now. And we need to act to move forward on this nominee, to give Merrick Garland an up or down vote, and do our jobs in the United States Senate. So now I would like to turn over the podium to former Justice John Broderick.
Thank you. Good morning. I want to thank Senator Shaheen for inviting me here today. I am not here for partisan reasons. I'm here because the federal courthouse is behind us. They are very special buildings in American life. It's what we talk about when we talk about our democracy. We're very proud of our court system. Chief Justice Roberts, in the weeks before Justice Scalia passed away so suddenly, said the nomination process needs improvement. And now we're at a point where we're shutting it down. So I agree with the Chief Justice. It's a self-inflicted wound to the United States, and it's so needless. The Supreme Court of our country receives 10,000 appeal requests every year. They take about 80 or 100, like a 1% chance of getting your case taken. And after those people with significant cases that the court itself thought need to be resolved, could go before a court with 8 judges and have a 4-4 decision, which is basically saying we can't get involved. Sorry you waited in line for 5 years. That's not necessary. 20% of all opinions of our Supreme Court, sometimes a little higher, sometimes a little lower, but on average, 20% of all opinions issued of those 80 are 5-4 votes. And many of them, not all of them, many of them would have been 4-4 votes. We don't need to have that happen. And I'm over 21 and I'm not naive. I know what's happening in Washington. But what I'm saying is it's not in the public's interest and it's needless. It's needless. And Justice Scalia's death, as tragic as it is, doesn't mean the world stops. Doesn't mean justice stops. Can you imagine waiting in line in this building after 4 years of litigation to go in here and they say, I'm sorry, we don't have a judge today. We can't decide your case. That can't be the way the American justice system works. So it needs to happen. And I will close with this. I'm a lifelong Democrat, I'm proud of that. But I'm not here today because I'm a Democrat. I'm here today because I'm an American citizen. And I grew up as a lawyer and a judge, and I respect this process. I devoted a lot of my life to it. And it shouldn't be used in this way, and it doesn't need to be. So I support the Senator's call to have hearings. And I hope people who can affect that result listen, because the American people don't deserve this. And it's not the justice system everyone here this morning is so proud of and that talk about. Equal justice under law, that's America. Not equal justice for some people some of the time. I hope they fill the slot. Thank you.
Thank you, Justice Broderick. Before I get started, I just wanted to make it clear that I'm here speaking on my personal behalf, and the views that I express today are in no way the views of the university or of the law school. So one of the first topics that I talk about in my administrative process class is the Appointments Clause. And I explain to my students why Article 2, Section 2 vests with the President the power, the sole power, to appoint the Supreme Court justices and officers of the executive branch. The U.S. Senate checks that power through their constitutional role to advise and to consent. However, this semester, this unit was a little more challenging for me to teach. Because as I'm attempting to impart doctrine, my students are watching an entirely different process unfold before them. They are witnessing the President announce his choice for the next Supreme Court justice, and the Senate refusing to execute their prescribed role in the process. Refusing to even consider meeting with a nominee or refusing to hold a hearing is arguably an abdication of the Senate's constitutional duty in the appointments process. Historically, the Senate has repeatedly confirmed Supreme Court justices in presidential election years. Since 1893, every Supreme Court nominee has received timely consideration from the Senate Judiciary Committee. Since 1975, the longest a nominee has gone without a hearing is 70 days, and the average is 42 days. It is even with the majority of the Senate Judiciary Committee did not support the nomination, the Senate Judiciary still considered the nominee and reported that nominee to the Senate for floor consideration. It is my hope that the Senate reconsiders their position and helps to move this nomination process through, and so by the end of the semester, I can again affirm to my students that the appointments process plays out as it should play out. Thank you very much.
Thank you. Thank you, former Justice Broderick and Professor Corcoran. We'd be happy to answer any questions.
Senator, have you spoken at all with Senator Ayotte about her position on this? Have you talked about, encouraged her to push for a hearing for the good of the state? What kind of conversations have you had?
I have not had a direct conversation with Senator Ayotte, but I have been clear from the very beginning in an op-ed, in floor remarks, and other comments to reporters that I think we need to move forward. And these remarks are aimed at the majority in the United States Senate, at Leader Mitch McConnell, Majority Leader Mitch McConnell, who has refused to say that he would give the nominee a floor vote. They're aimed at Judiciary Committee Chairman Chuck Grassley, who has said he's not going to hold a hearing on the nominee. And it's aimed at everybody who is refusing to consider this nominee in an election year. You know, when we took that oath of office, it didn't say, I will defend and protect the Constitution only in non-election years. It said I will do it in my entire tenure in the United States Senate. Now, should we say anytime there's an election year for a senator, we're not supposed to act on votes that may be controversial or some people may be unhappy about? No, it says we act the whole time. And so it's really, as Justice Broderick and Professor Corcoran have pointed out, this is the first time in the history of the United States that the United States Senate has taken a position that says we are not going to act on a nominee to the Supreme Court. That is You know, as I travel around New Hampshire, one of the things I hear from people most often is, why can't you all work together to do the business of this country? And this is an issue that is critical to the business of this country, and we need to work together. We need to go forward with a hearing and give Justice Garland an up or down vote.
Senator,
Yes.
Governor Hassan has said a number of times in the last couple of weeks that Senator Ayotte and fellow Republicans in the Senate are not doing their job by not having these hearings. Do you agree that Senator Ayotte or the Republicans are not doing their job?
Well, as I've said, I think the Senate needs to do its job. We need to move forward with a hearing on Merrick Garland. We need to have an up or down vote and decide whether we are going to confirm his nomination and do the work of the people of this country. You know, back in 2001, when Trent Lott was the Republican leader in the Senate, one of the things he confirmed was that even if a candidate didn't get a majority vote in the Judiciary Committee, they were going to get an up or down vote on the Senate floor. That's what we need to see happen this time. There needs to be a hearing and an up or down vote, and we need to move forward with the people's business and do our jobs.
Senator, what the
Yes.
Republicans have said is essentially if this political situation were reversed, they would expect the same behavior out of Democrats.
But that's just not true, Josh, because what we saw in 1988, the last time this was an issue where there was an opening on the Supreme Court, is that the democratically controlled Senate gave Ronald Reagan's nominee, Anthony Kennedy, a hearing and a vote and confirmed him 97-0. So it's not true.
Well, times have changed. I mean,
Well, they may have changed, but the history has not changed. And the fact is that hasn't been the case. And I believe, regardless of who the president is, regardless of the control of the Senate, as Trent Lott said, the nominee needs to have an up or down vote. I don't care whether it's an election year or not.
Senator, outside of the court of public opinion, what else can you do, or what can anyone do to force this through?
Well, I think it is the public out there talking to their elected senators that will make a difference. And we've seen some change happening as the result of that. Senator Mark Kirk from Illinois has said that not only is he willing to meet with Justice Garland, but that he thinks the Senate should give him a vote. So I think we're beginning to see a response from senators based on what they're hearing from the public.
Do you see it as progress that Senator Ayotte has said that she'll meet with Garland?
I think all of the senators should meet with Justice Garland and give him a hearing and give him an up or down vote.
Senator, I know you said this is not political, but you're having a high-profile news conference. You've got a lot of members.
I didn't say. What I said was that the process for appointing a Supreme Court justice has not been partisan in the past. And it has not. Historically, it has not. And what I think is important for me to do is to let the people of New Hampshire know where I stand, that I think it's important for the Senate to go forward, to do our jobs, to act on this Supreme Court nominee. Thank you all very much.